A very good evening, everyone, dear colleagues, dear friends, dear students. A very warm welcome to this event on rule of law backsliding in the European Union with Professor Laurent Pech from Middlesex University in London. My name is Mathieu Burnet, and I'm an associate professor in global law at Queen Mary University of London, where I also have the pleasure to coordinate the Jean Monnet Network on EU-China legal and judicial cooperation. So it is in this context that this event is taking place, but also in the context of the activities which are organized by the Association des Juristes Queen Mary Sorbonne. I mean, to my knowledge, there is no English translation to the name of this student association, which indeed represents the students who are part of the double degree in English and French law, which Queen Mary runs with Paris 1 Panthéon Sorbonne. So I'm very pleased to see that many students from the double degree have joined us tonight to have indeed a very promising discussion on a very hot topic. I mean, in the European Union, which is the question of the protection of the rule of law within the European Union, the rule of law, which is one of the key values upon which the European Union and the European integration process has been based, and which is very much encored as a constitutional principle in Article 2 of the Treaty on the European Union. And tonight, to talk about this important issue and indeed the very threats, the systemic threats against the rule of law within the European Union, we have a very good speaker and also a good friend of mine, Professor Laurent Pech, who is a professor of EU law and also head of school at Middlesex University School of Law. Laurent is also a visiting professor at his alma mater, the University of Bordeaux in France. And a number of things which you should know about Laurent is the fact that he's part of an important H2020 project whose purpose is very much to study, I mean, the challenges, but also the protection, the prospects for the further protection of the rule of law in the European Union. And I would also like to flag the fact that Laurent Pech has very recently launched a very important initiative, which is the Good Lobby Prof, if I'm correct with the acronym, Laurent, which is a rapid response. Which is a rapid response initiative bringing together more than 60 academics from all over Europe, whose purpose is indeed to provide a rapid response may some new threats to the rule of law occur in the European Union. So I would like to invite everyone indeed to follow the activities of the Good Lobby Prof, and I will post on the chat, the link to the website in a moment. So Laurent will be presenting tonight during 40 minutes, and after his presentation, we'll have the pleasure to hear our discussant, Professor Valsamis Mitsilegas, who is with us tonight, who I would like to thank very much indeed for having kindly agreed to also contribute to this event. Professor Mitsilegas is very well known by many of our students. Indeed, he's the former head of department, head of the School of Law at Queen Mary University of London. And Professor Mitsilegas' research indeed has very much focused on the issue of the rule of law in the particular area of judicial cooperation in criminal matters within the European Union. So in that sense, I think that Valsamis' addition and contribution to the event will definitely be very complementary to what Laurent has to say about this particular topic tonight. So thank you again, Laurent and Valsamis, for being with us. And Laurent, the floor is yours. Thank you again for being with us.
Thank you very much, Mathieu. I have prepared some slides for you to make it easier to follow my talk tonight. And so essentially about 30-40 minutes to discuss what Mathieu has described as a very pressing topic. He said controversial topics perhaps, but I would say also possibly depressing. So hot and depressing, possibly topic of discussion. When I was an EU law student, and in fact, when I started my professional career, I started as a rule of law consultant for the EU, but in EU candidate countries. The rule of law was not supposed to be a pressing issue to be discussed regarding the situation within the EU. Sadly, the situation has dramatically changed in the past essentially 10 years. rule of law backsliding has become not only obviously an issue for non-EU countries, but has become a very pressing issue from within the EU itself. Before I tell you what rule of law backsliding is, from my point of view, I guess it's always good to start with what is the rule of law. Surprisingly, it's not that difficult in EU law to find a definition of the rule of law. And here you're just looking at the latest definition adopted by the EU institutions. I mean here the Council of the EU and the European Parliament. This is Article 2 of Regulation 2092/2020. Now, where is this definition coming from? It actually just very much is based on a previous definition of the Commission from 2014, which itself reflected a definition of the Venice Commission from 2010. Both definitions of the European Commission and Venice Commission are essentially just a codification of the case law of the Court of Justice and the European Court of Human Rights. This definition is not controversial at all. So essentially, it's just it gives you a list of the core components of the rule of law. This definition, I would argue, and in fact, I have defended the view in my research that this definition is very consensual, and you will get essentially the same national definition in every single legal system in the EU. Now, why did the EU feel recently the need to adopt this definition in this specific instrument, which I shall come back to at the end of this presentation? Just because a new argument has been gaining ground in Warsaw and Budapest. So the two main sources of contestation when it comes to the rule of law these days in the EU. The Polish government and the Hungarian government have now been increasingly arguing that the rule of law is not a legal concept, does not exist in EU law, and cannot be defined in EU law. Indeed, this is one of the legal grounds they are now raising before the Court of Justice in their annulment action directed at Regulation 2092/2020. So this definition is part of a legal instrument, which is now being the subject of a legal action brought by the Polish and Hungarian governments. I don't have the case number in mind now, but you can easily find it online. Most likely we'll get a judgment from the Court of Justice by early 2022, if not before. But this is the first time in the history of EU law and in the history of the Court of Justice that a member state dares actually making a formal claim before the Court of Justice that EU law, essentially that the rule of law is not a legal principle, it's an expression. That's what they use in their annulment applications. So the rule of law, they use quotation marks and they say it's an expression which cannot be defined in EU law. So this is a very strong claim. This is a claim which is essentially, to put it bluntly, makes no sense. In fact, to join the EU, you have to agree to one of the core components of the EU acquis, which is compliance with the rule of law. Anyway, you can ask me questions about whether the rule of law is and can be defined in EU law, but I'm willing to bet with Professor Bernet some very expensive fries in Brussels that this argument will be dismissed, and quite sharply, by the Court of Justice in this pending annulment action. But the bottom line at this stage is, I would argue, we have indeed a very clear-cut, uncontroversial definition of the rule of law in EU secondary legislation. So this is the definition you're looking at. Now that we know what is the rule of law, I'm going to try to tell you what I think is rule of law backsliding. So here we're talking about rule of law backsliding, but you could as well argue that you could call this democratic and rule of law backsliding, because whenever rule of law is being undermined, automatically it has a negative impact also on democratic checks and balances. Rule of law backsliding is the expression I tend to use myself in my own scholarship. Here you have a definition we suggested with Professor Schepelet in an article published in 2017, where we essentially look at what the EU has been doing in relation to Poland and Hungary. So that was from 2017. And in this article, we explain, or we try to explain essentially what has been happening in Hungary since 2010 and in Poland since the end of 2015. we use the expression constitutional capture recipe. So this is essentially, what do I mean by constitutional capture recipe as well? So we're talking here about the process. So here we're talking about the process, not the end result. So rule of law backsliding is a process on the basis of which essentially the newly elected authorities are going to try to dismantle checks and balances in order to capture the constitutional system. So this is what I use. I borrow the notion of capture from EU competition law. You know, when you have a capture regulatory body, or when you try to capture an institution. So essentially here we're talking about a process. You have a system which was more or less working fine. And then you're going to deliberately try to make the situation worse from a rule of law point of view. So it's not the same as essentially the usual rule of law shortcomings you may see in a number of countries. A number of countries suffer from severe rule of law shortcomings, but it's not because they want to, it's because they've been failing to essentially address these shortcomings or because of state resources missing. Here, in the case of Poland and Hungary, from a rule of law point of view, their systems were quite actually average or relatively healthy before 2010 and before 2015. But after Orban and then in the case of Poland, Kaczynski won free and fair elections, respectively in 2010 and then 2015, they essentially engaged deliberately in a process of systematically weakening, annihilating, or capturing internal checks on balance and checks on power. What is the goal here? The recreation of a de facto one-party state. So they are still keen to call their systems democratic. Remember, Orban has been trying to argue that what he's creating in Hungary is not an authoritarian regime, but rather an illiberal form of democracy, which in my view does not exist. It's like saying a democratic dictatorship. It simply is not it's neither a democracy nor one based on the rule of law. Anyway, we can discuss my definition later, but what is clear is that this is a process, and this is a deliberate process to make the situation worse from a rule of law point of view. The goal is to destroy the system, if I can be so blunt, before the next legislative elections are due to take place. Part of this process, a core component of this process is the essentially the undermining of the electoral framework prior to the next elections. So you still have free elections in both Poland and Hungary, but they are no longer structurally fair. This is a diagnosis of the OSCE, by the way. So there has not been fair elections in Hungary since 2010. Same story in Poland since 2015. You have had structurally unfair elections. Because my time is limited, I'm not going to give you more details about what does that mean, unfair elections from a structural point of view. But in a sense, it means you capture the electoral regulatory body. You change the rules essentially to make it virtually impossible for the opposition to win power unless they obtain about 60–65% of the votes in practice. So you no longer need to command a majority in such a system to keep winning elections. You just have to make sure you have a number of tools you can use to make sure that you never lose elections. And now that we know what is the rule of law, what is rule of law backsliding, let's discuss rule of law backsliding in more general terms. I have described rule of law backsliding myself as the key existential challenge faced by the EU legal order. I'm not denying that the EU has quite a lot of key challenges currently, but my diagnosis was prior to the COVID-19 situation. So starting in 2016-17, I have increasingly described the rule of law backsliding as an existential threat, not for the EU itself directly, but for the EU legal order. I will explain in a minute why. Why am I so worried about the functioning of the EU legal order, and why rule of law backsliding is a threat to the EU legal order. But what is interesting is to understand that, or at least for me, to highlight the fact that politically speaking, rule of law backsliding has also been recognized at least as one of the most pressing challenges faced by the EU. And here you have an example of a former vice president of the European Commission in January 2019, mentioning Poland, Hungary, and then Romania was in the news as three of the then backsliding countries in the EU. And for him, and I would agree, that's why I'm using his quotation here, this is the biggest challenge the EU is currently facing. Why is it worth highlighting? Because it took a long time before essentially this became consensual in Brussels. So to view rule of law backsliding as a pressing threat, it did take many years before we get to this point. In fact, it wasn't before 2019-20 that most people accepted that rule of law backsliding, the way it was happening in Hungary and Poland, was something quite worrying, something unprecedented from the point of view of the EU. This was not, however, the first time the problem was identified. So 2019-20 was just the time when the problem was more widely acknowledged. But the first time the problem itself was publicly acknowledged by a key EU official was President Barroso in State of the Union Address 2012. This is the very first time officially the situation in Hungary is acknowledged as posing a new type of threats. So in this speech, Barroso referred to threats to the legal and democratic fabric in some of our European countries. Back in 2012, Orban's Hungary was in the news, but also Romania, again, already was mentioned. And more surprisingly, possibly, Sarkozy's France was one of the three countries which was highlighted as problematical by Barroso. Long story short, as regards France, at the time it was discovered that the French government was attempting to collectively deport Rome people on the basis of a secret ministerial instruction. The rule of law crisis in France didn't last long because all of these secret administrative instructions were swiftly annulled by the French admin judges. So only essentially the situation in Hungary remained problematical because also the situation then existing in Romania, there was a conflict regarding compliance with judgments of the Constitutional Court, was also solved through a dialogue back in the day between the Commission and the Romanian government. Perhaps worth mentioning that Romania and Bulgaria have been also subject since they joined the EU to a special rule of law mechanism. So he hasn't really worked well, but he gave an extra stick to the Commission to use against Romania back in the day. So it was not, in fact, simply dialogue working in the case of Romania, but the so-called cooperation and verification mechanism, which is still in existence, even though it was not supposed to last for more than 2 or 3 years post-EU accession. So we're talking here about 2006. This cooperation and verification mechanism was put in place in respect of Romania and Bulgaria. A few years later, situation went completely out of control in Romania. Anyway, in 2021, only one of these 2012 countries has remained a problematic problem, and then a new country has emerged as a particularly problematical, Poland, and this started in 2015. But I just want you to understand that rule of law backsliding is nothing new. So this is not something we discovered last winter or in 2019. We've been dealing with this or rather not been dealing with it for many years. And this is why now the situation is getting out of control in both Hungary and Poland. And I will explain what I mean by out of control soon. Now, but before I do get to the specific aspects possibly of Poland and Hungary, why should we worry, or why should we even care about rule of law backsliding from an EU law point of view? And in fact, it's very easy to explain why we should worry about it from an EU law point of view. What you're looking at here are 2 paragraphs from opinion 2/13 of the European Court of Justice. So this is, it doesn't matter where it's, I mean, the source, but essentially this has been repeated over and over by the Court of Justice in the past 10 years. The bottom line, if I have to summarize, is according to the Court of Justice, and I do strongly agree, the EU can be represented in the form of a structured network. I quite often speak myself of an interconnected ecosystem. So the EU legal order can be viewed as an interconnected legal ecosystem. What essentially my point is, what's happening in Poland, what's happening in Hungary in such an interconnected system has automatically a knock-on effects on the rest of the EU. Think about mutual trust. Think about mutual recognition of judgments, which is the area of expertise of Alsamis. So we can discuss this aspect possibly later. Think about European arrest warrants. Think also about the fact that Polish and Hungarian authorities are able to define in part EU rights and as well as EU obligations through their participation to the EU's decision-making processes. So obviously, Hungarian government as a commissioner, as obviously a member of the council, as MEPs, even though they've just been kicked out of the EPP. So they do have plenty of ways of shaping EU law. And when you have an interconnected legal system, which is technically based on the fundamental premise that you can only be part of this system when you comply with the rule of law, democracy, and respect for human rights, well, there's something which is not working, which cannot work. And now we're actually reaching the stage. We are essentially close to crunch time, at least as far as Poland is concerned. I'll get back to Poland, but you don't have to agree with me. But from my point of view, Poland has already kind of exited from the EU legal system. So we have seen already increasing de facto Polexit from the EU legal system. Why? They have legislated to essentially prevent Polish judges from complying with EU rule of law requirements, including the case law of the Court of Justice. Complying with EU law judicial independence requirements is essentially, to put it bluntly, a crime under Polish law now. So a Polish judge applying EU law, judicial independence requirements could be dismissed from the profession of judge in Poland. A Polish judge submitting questions to the Court of Justice can be also the subject of disciplinary sanctions up to dismissal. This is where we are in 2021 in a system which is interconnected. So this is why we should have to worry about this. This is why I have described it as an existential threat to the functioning of what is an interconnected legal system. Now, maybe this is all abstract for you guys, so I've decided to share some diagrams. It works better when you can visualize the problems, I think. So I have here some diagrams, some photos from different sources. Here you're looking on the slide, you're looking at the World Justice Project Rule of Law Index 2020 edition on the left side of the slide. And then on the right side, you have a graph from Freedom House Nations in Transit report from last year as well. So these are two very good annual reports assessing essentially to what extent the rule of law is complied with worldwide in the case of the World Justice Project. Freedom House is only about Central and Eastern European countries, mostly essentially what they call nations in transit, but they also include Russia. They look beyond the EU. But what you can see is that both agree that something went deeply wrong in the case of Hungary. According to World Justice Project, Hungary is 24, so in the EU EFTA essentially ranking or group, Hungary is last. So this is the bottom EU member state when it comes to compliance with the rule of law. In the world, when it comes to constraints on governmental powers, it's actually just above China. Just to give, because I know Mathieu is very keen on China, so this is why I'm making a direct comparison between Hungary and China. They have different benchmarks to essentially assess compliance with the rule of law. Can you imagine? We have an EU member state, which is in the bottom 50 countries in the world, just above Russia and China when it comes to constraints on the exercise of governmental power, or rather the lack thereof in this case. Now look at the Freedom House also a 10-year essentially graph. Hungary started as a consolidated, or was already a consolidated democracy, according to the Freedom House in 2010. Now, 10 years later, no longer a democracy, or at least it is now ranked as a hybrid regime. So no longer quite a democracy, not yet a full-fledged authoritarian regime. Now, you might say, well, 2 reports is not quite enough, so I decided to add one more report on my next slide. This is also from the World Justice Project, by the way, but this one is new. This is from another source, which is known as the VDEM Democracy Annual Report. VDEM is a research academic institute, essentially specializing in the study of democracy. This is the top 10 autocratizing countries in the world for the period 2009-2019. Actually, the latest report just came out 2 weeks ago, but so I could change. There is a more recent top 10. You'd be glad that actually there's been a change in the ranking. So this is almost as exciting as FIFA football or rugby rankings. You have always constant changes. And this is a quiz question for you guys now. Who's number 1? Hungary is no longer number 1, has become number 2. There is now a new number 1 country in terms of autocratization. So essentially, you can either democratize or you can autocratize. It's not easy to say, but essentially, what does it mean? It means these are the countries which have destroyed democracy and the rule of law the most in 10 years. Doesn't mean they are the worst countries in the world. They are the worst when it comes to actively undermining democracy and the rule of law in the past 10 years. Number 1 spot this year goes to Poland. Poland is now, according to the VDEM expert, the country which has undermined, not to say destroyed, the rule of law the most in 10 years. And it's quite impressive because they only started at the end of 2015. So in 5 years, essentially, we're able to get to the spot number 1. Hungary, also something worth paying attention to, no longer democracy according to these democracy experts. They refer to Hungary as an electoral autocracy. Poland is no longer a liberal democracy, but is considered by these democracy experts as an electoral democracy, meaning that essentially it is no longer it's no longer a democracy where the rule of law is complied with. So you still have elections, but essentially rule of law has been systemically undermined. So this is where we are in 2021. Can you imagine? Just think about it for a minute. You cannot join the EU unless you comply with a number of fundamental values. That's what we've been saying to Turkey, for instance, for 40 years. And what do we see now in 2021? The 2 worst countries in the world in terms of destroying the rule of law and democracy are 2 EU member states. In the top 5, we have also 2 EU candidate countries. So much for the EU as a normative power, which I remember quite strongly from my time as a student. When I was a student, I was told and taught that the EU was a normative power whose main added value was to bring democracy, the rule of law, respect for human rights abroad. And in fact, we used to argue that EU enlargement, the key added value of EU enlargement was actually to democratize the countries through the enlargement process. I'm not saying I don't believe in enlargement. I'm just saying that we've come a long way from the days of the EU as a normative power, from the days where every member state was supposed and could legitimately claim to be a democracy based on the rule of law. I'm not saying everything was perfect 20 years ago, but I'm saying 20 years ago, we didn't have a clear authoritarian regime in the EU, at least electoral autocracy, if you don't want to call Hungary an authoritarian regime. But we have to agree with the experts here. This is the top 10 from the VDEM experts. They have the most sophisticated database in terms of measuring countries' adherence with the rule of law. It might be also of interest. They have just they also are measuring these days academic freedom now. Also, that's quite new, which is also usually one of the key targets of would-be autocrats. Is always so they always go after judges, lawyers, prosecutors, but also academics. Now, I'm going to tell you about the toolbox. I think I have about 10 or 15 minutes left, more or less. And I mean, I can go on, and in fact, there's so much to say, but I would rather answer questions. So I'm just going to give you some, I'm going to make some brief comments, and I'm not going to go through every single tool in the toolbox, because the rule of law toolbox of the EU has grown quite dramatically in the past 10 years. So you could distinguish between about, I would say, 10 different tools: legally binding tools, non-legally binding tools. Here, essentially, I've included the most important or the most well-known tools on this slide. The infringement procedure, which is to be found in Article 258 of the TFEU. I'm not sure if all the students are lawyers, or law students rather, but so if I'm just being too complicated, Mathieu, just let me know. So infringement procedure, very briefly.
All good, Laurent.
Yeah. So essentially, it means that the European Commission can sue a member state and bring the member state before the Court of Justice for any breach of EU. This has been in the toolbox since the 1950s, so nothing new here. Preliminary ruling procedure, same since the 1950s, so this is why they are on top, at the top of my list. Preliminary ruling procedure means essentially that any national court anywhere in the EU can refer questions of EU law to the Court of Justice and get so-called a preliminary ruling, a preliminary judgment. We have plenty of examples of rule of law related infringement judgments and preliminary ruling judgments, but actually they're quite recent. So this is why, in fact, I'm not going to tell them until the very end about the infringement procedure and the preliminary ruling procedure, because they were used quite late in the day to deal with rule of law backsliding. Instead, the EU has tried to use Article 7 in the case of Poland and Hungary to deal with what I have described as rule of law backsliding. Article 7 has been known as mislabeled the EU's nuclear option, but I will briefly explain why this is wrong. And then I'm going to tell you about the two latest kids on the block, the Commission's rule of law cycle, or rule of law report, and then this new rule of law budget conditionality regulation, which is regulation 2092/2020, which is the subject of an annulment action, as I was just mentioning at the start of this lecture. So very briefly, and I have to oversimplify, but Article 7 TEU was labeled the EU's nuclear option by President Barroso, which I think was a bad mistake, because then obviously you don't want to use nuclear weapons, because if you do, then everyone is dead, and only zombies can then survive. So because of this mislabeling, in fact, Article 7 TEU was not used until very late in the day. He has been used, in fact, before I tell you when he was used, it was also wrong to describe it as a nuclear option, because in fact, Article 7 contains two different mechanisms, one which is of a preventive nature, and then one which is of a sanctioning nature. Article 7 of a preventive nature is the one which has been activated in respect of Poland and Hungary, respectively in December 2017 and September 2018 for Hungary. So we have two examples. We have two pending Article 7, paragraph 1 proceedings. Now they are now stuck in the Council. The Council is the key decision-making player here. Long story short, the Council has been busy trying to do as little as possible under these two Article 7, paragraph 1 proceedings. I just don't have time to explain the political, essentially, factors. But currently, these two proceedings have been suspended officially because of COVID-19 TEU, which, let me just put it in a few words, it's just not credible, but that's the official excuse that legally speaking, they cannot have video conferencing for Article 7, paragraph 1 hearings. The best outcome you can have, anyway, there's nothing to be excited about, even if Article 7, paragraph 1 was actually effectively used by the Council, which it is not. The best outcome you can get are non-binding recommendations, which may or may not be complied with. And then at the end of the road, you get a determination that there is a threat. That's it, nothing else. The best outcome, the most severe outcome is political finding that you have a pressing threat as far as the rule of law is concerned. There has been no vote, not even an attempt to get to the 4/5 majority which is required in the Council. The sanctioning arm of Article 7, which could result in real sanctions, including, for instance, the suspension of the voting rights of the Polish and Hungarian governments, has not been attempted. Why? Because of the unanimity requirement before sanctions can be adopted. Long story short, the Polish government and the Hungarian government have agreed. They've made a pact that they would veto each other's sanctions under Article 7, paragraph 1 TEU. There are ways, I think, of bypassing this veto, but you would need to have creative lawyers in the Council and the Commission, and they're not known for going essentially for being too creative, especially in the Council. In fact, in the Council, they've done their best to undermine the rule of law efforts, but my time is limited, so I cannot tell you much more about this. But this is Article 7, TEU. It is currently being used in respect of 2 countries, but you cannot expect much out of them. Even though in this context, we've seen good documents being produced, which can then be used by lawyers and national courts. Now, the rule of law cycle, that's new. New since last year, at least. So long story short, actually the slide is wrong. First edition was in September 2020, not 2019. So the rule of law cycle was announced in 2019, first used in 2020. What does that mean in practice? It means a number of country reports, so 27 country reports plus a transversal report. So a lot of information. So if you're interested by your own member state, so if you're from Romania, France, or Spain, you can find the country rule of law report drafted by the Commission available on the website of the Commission. If you're interested by more critical assessment, I have included on the slide what I wrote last December. So I'm quite critical of the rule of law cycle / rule of law report, if only because essentially you don't have any consequences attached to it. So it's not a legally binding exercise, just a reporting exercise. You cannot, the Commission has committed itself not to use the findings of its reports in infringement actions. So, I mean, where to begin with this, but it does offer plenty, I guess, of information, which a rule of law experts would know about anyway. I guess the added value is that it does force the EU and especially national governments to discuss rule of law on an annual basis. Second edition is scheduled for July 2021. So we'll see second edition to be published of all these country reports in July 2021. Something which is even more recent, the rule of law budget conditionality, also known as the rule of law conditionality regulation. For the first time, the EU Commission has been given the power to suspend EU funding directly on rule of law grounds if the Commission is able to prove evidence generalized deficiency. In fact, the concept itself has disappeared, but this is what it is. Excuse me. Essentially, the Commission can suspend, freeze EU funding as regards a specific member state if the Commission can prove that some specific principles of the rule of law have been breached. The Commission must link these breaches of the rule of law to the use of EU budget or EU financial interests. So not easy as it sounds. There is a legal test to be satisfied, but this is the very first time you can directly suspend rule of law funding, EU funding, generally speaking, on rule of law grounds. You have, interestingly enough, this regulation offers specific examples, concrete examples of what is a breach of the rule of law. So this is actually quite good. But the legal test is quite difficult to satisfy. A breach of the rule of law is not enough to freeze EU funding. You have to connect the breach of the rule of law to EU budget / EU financial interest. This rule of law regulation has been subject, or is the subject of an annulment action before the Court of Justice. The Commission has committed itself not to apply the rule of law regulation until after the judgment of the Court of Justice has been issued. If you want to know why this is a direct breach of EU primary law, you can just read the post listed on the slide, which I co-authored with Professor Chipelet and Professor Platon. This was done as part of a compromise negotiated by Merkel when Germany was in charge of the rotating presidency of the Council from last July until December of 2020. It was called the German Compromise. Now, we all expect the Court of Justice, I mean, I do expect the Court of Justice to fully validate this regulation. I don't think there is any chance. I mean, none of the arguments raised by the Polish and Hungarian governments have any hope of surviving judicial scrutiny as far as I'm concerned. Then the Commission will adopt so-called guidelines regarding how to apply the conditionality regulation. I would expect the conditionality regulation to be applied first and foremost to both Poland and Hungary. And then things are going to become interesting. Why? Because this rule of law conditionality regulation is also the subject of a constitutional review action initiated by the Polish government and brought to the attention of the unlawfully composed Constitutional Tribunal of Poland. So they're asking their friends to say that this rule of law conditionality regulation is not compatible with the Polish constitution. So we're going to have some interesting, massive, open conflicts in 2022. You heard it first on this Zoom call, thanks to Professor Bernay. So plenty of, I'm predicting the EU law future here, and you can hold me to it if I'm proven wrong in 2022. You can expect also Orban to do the same, to use his captured constitutional court to, if need be, find this EU regulation in violation of the authoritarian constitution Orban adopted very early on in his reign. This is something new. This is actually something possibly worth discussing later. The new autocrats, they create fake courts, which they can then use to essentially undermine real courts and undermine the primacy of EU law. So it gives them a veneer of legality to justify what is completely unlawful. But now I have to tell you about two old tools from the EU toolbox, infringement procedure and the preliminary ruling procedure, very briefly if I can. So this one is something the Commission has been doing for decades. So essentially the Commission can bring and does launch plenty of infringement actions every year. Last year, in 2019, actually, I don't know about 2020, Commission launched about 800 infringement actions in 1 year. Sadly, from my point of view, the Commission had waited too long to actually try to defend the judicial independence through infringement actions. He has done so only in 4 occasions to date. So we have only 4 infringement actions in the history of EU law seeking to protect judicial independence of national judges. The 4th case was lodged today with the Court of Justice, or rather is about to be lodged by the Commission. Press release was published today by the European Commission regarding the so-called muzzle law, that's the nickname of this legislation adopted by Polish authorities. In a nutshell, this muzzle law has organized a de facto polexit from the EU legal order. So this is the legislation which is going to be brought to the attention of the Court of Justice, finally. Interestingly enough, the Commission has also asked for interim measures. So that's as part of infringement proceedings, you can ask the Court of Justice to suspend the application of national legal provisions, and the Commission has done so. What is even more interesting and worth noting, the Commission has asked for the second time for the Court of Justice to suspend the functioning of a national body which thinks of itself as a court. It's not a court, but the so-called disciplinary chamber, which is essentially what I have described in my scholarship as the equivalent of the English Star Chamber from the Middle Ages. which is a body designed to harass, punish, persecute Polish judges. This disciplinary chamber was suspended by the Court of Justice last year, but they have ignored the ECJ order. So now it's round two. The Commission is going to ask the Court of Justice to again suspend the functioning of the disciplinary chamber, not only as regards disciplinary cases, but also criminal, or should I say sham criminal proceedings brought against Polish judges. This is what they're doing these days in order to bully judges into submission. They not only subject them to disciplinary measures, but they also bring bogus criminal charges. So then the judges have to defend themselves for years before a criminal court. And while they defend themselves in criminal proceedings, they are automatically suspended plus subject of pay cuts. So this is where we are, the EU 2021. So bottom line, infringement actions only for today to defend judicial independence. In my view, a lot more can be done under this infringement action. So possibly we didn't have to reinvent the toolbox. We just have to apply more forcefully the old tools. Same for the preliminary ruling procedure, and that's going to be my last slide. This is again an old procedure from the 1950s. The problem with this procedure is that technically the Court of Justice, the jurisdiction of the Court of Justice is limited. The Court of Justice can only answer questions from national judges in the abstract. So the Court of Justice cannot, under this procedure, directly apply the EU law to the facts pending before the referring court. It is for the referring court to do so. The problem is that whenever the Court of Justice does issue a very important preliminary ruling, then what we've seen in the case of Poland is that judges are subject to disciplinary measures if they dare applying the ECJ judgment. So this is kind of a loophole in the preliminary ruling procedure, which is why also the Commission sued Poland today on the basis that they were undermining the functioning of the preliminary ruling procedure. Now, there is a very interesting, really worth noting judgment issued by the Court of Justice in AB, that's the name, on March 2, 2021. I have analyzed this judgment here for the blog of Professor Steve Pearce. This is essentially a very important preliminary ruling judgment, even though the Court of Justice does not apply its interpretation of EU law to the facts of the case. The way it must be applied is crystal clear. Essentially, the Court of Justice has made clear that the referring Polish court has no choice but to find the relevant measures of Polish law completely incompatible with the principle of judicial independence, including essentially the fact that the disciplinary chamber is not a judicial body composed of judges. What happened after this AB judgment issued by the Court of Justice? Can you guess? Well, a new motion from the Polish government to the Polish Constitutional Tribunal, which is no longer a court, to essentially prevent the application of this ECJ judgment. At the same time, what we've seen is that unlawfully appointed judges are using other unlawfully appointed judges to also prevent a judgment from the European Court of Human Rights of December 2020, which is known as the Icelandic judges case. So long story short, preliminary ruling procedure is now increasingly used to raise or bring to the attention of the Court of Justice judicial independence matters. The Court of Justice is increasingly more vocal in its defense of judicial independence. The gap or the loophole in this procedure is that you still need independent national judges left to apply the judgments of the Court of Justice. If you have no national judges left, or if they are going to be subject to disciplinary and or criminal charges for applying a judgment of the Court of Justice, obviously then you're stuck, which is why it is so important for the Commission to do its job under the enforcement action. We cannot ask Polish judges and judges elsewhere to risk their professional and family life only because the Commission is not bringing enough enforcement actions to the attention of the Court of Justice. Let me end on a figure. I'm going to give you two figures. To date, as regards the situation in Poland, we have now, since today, 4 infringement actions raising judicial independence / rule of law issues. Polish judges have submitted 36 or possibly 37 national requests for a preliminary ruling raising rule of law issues. One of the judges who submitted the preliminary ruling request, Judge Igor Tuleya, has since been unlawfully suspended, subject to a pay cut, plus is the subject of bogus criminal proceedings, and he might be arrested at the end of April because his judicial immunity was unlawfully waived by the body known as the disciplinary chamber, which was supposedly suspended last April 2020. This is what rule of law backsliding means in concrete terms. We have people, we have real victims of this rule of law crisis in the EU. And thank you very much, Mathieu.
Thank you very much, Laurent, for this very forceful and comprehensive presentation of some of the key issues at the heart of this process of rule of law backsliding on the one side, but also for this very comprehensive and critical presentation of the toolbox at the disposal of the EU. So the least that can be said is that the instruments exist, but that they do not seem to be satisfactory in terms of responding to the challenges you've just described here. So thank you very much, Laurent. What I would suggest now is that we move on to Valsamis, to Professor Mitselegas, for a short discussion. Valsamis, for the sake of time, I kindly ask you to stick to 5 minutes. And since there are, I think, a number of questions which you may also want to be willing and definitely able to address, maybe what we could do is to have a kind of interactive Q&A in which both you and Laurent could be involved. So for the discussion, it would be excellent if you could stick to 5 minutes, please. Thank you.
Thank you, Mathieu. That was my aim anyway, and let's see. It's a great pleasure to be here. Also, as one of the fathers of our double degree with the Sorbonne, it was one of the great achievements of my headship to get this degree approved and launched by the university. And I'm really so thrilled that this degree is going from strength to strength and you're all here. This is one of the jewels of the crown of Queen Mary offerings, especially in the current post-Brexit age, and we hope to continue to keep our links strong. And many thanks to Mathieu actually for leading on this program. So it is great to see you all here, and this was a great presentation, and it's very tempting really to give another presentation just commenting on what Laurent has just said, but I just want to make 3 remarks and then we can open it to discussion, trying to weave also some of the questions that I saw coming in the chat. And I think that it is really interesting because we saw that, and it is interesting that the rule of law challenges are also challenges for EU law. EU law and EU institutions have been taking more or less rule of law for granted. And Laurent mentioned the old days of enlargement. And we thought then that we had the Copenhagen criteria and an enlargement process whereby it was a civilizing process for the candidate countries, that there was no rule of law problems within the EU, and that once these countries became EU member states, everything would be solved magically. And the cooperation and verification agreement was really a very interesting experiment, because for the first time you had an institutionalized mistrust, rule of law mistrust towards EU member states. So we had Bulgaria and Romania being subject to monitoring, which continues today. But there are many challenges, I think, for EU law, both for the law itself and for the EU institutions, and these were highlighted. The first one is, of course, what is the rule of law and what is its legal force? And Laurent mentioned that there is now a definition in secondary EU law on what the rule of law is. Rule of law, of course, it's in the treaty stated as a value. We think we know what it is. The current challenges at national level involve mostly authoritarianism and judicial independence. But I just want to throw to you, if you're interested in the topic, to see how the EU definition squares with your own understandings of the rule of law, also from a comparative perspective. We have Dr. Mendes here, who teaches you public law, and those of you with a French background, how does this square with the État de droit? How does it square really with the Bingham's famous definitions of the rule of law, in an English law context? So it's interesting to reflect on whether the definition is adequate and what is really the legal heritage, if you like, of this definition. But for the EU, I think this is not the main complication. The main complication is what is the legal value of the rule of law and how is it best enforced. And for the legal value, I think it is interesting because it is a value of the Union. There was a big debate for a long time, I think, about the justiciability of EU values. And I think that may explain really what Laurent mentioned, that the initial reluctance of the Commission to bring infringement proceedings specifically on judicial independence and the rule of law, because initially the first cases that we had, if I'm not mistaken, were cases where the Commission was trying to find a link with a substantive EU policy. So, you had attempts to link it with anti-discrimination law because it was felt that this was kind of justiciable, whereas, if you go straight on Article 2, that wouldn't be enough. So, so there is this, I think, dilemma on what is the legal value of the rule of law and the justiciability in the EU legal order. But since then, we have had many opportunities for the Court of Justice really to define elements of the rule of law. And we see, in a sense, within this crisis, which is really unfortunate, the opportunity for EU institutions, especially the Court of Justice, to come into its own and to provide really a meaning to the rule of law, which is a European meaning to the rule of law. And I find this quite an interesting development. Now, how is it enforced? And I think the presentation was really fantastic to show the gaps that we have now in the European Union. So we have a political gap, and I'm not going to go any further on Article 7. I think that was mentioned, really clearly in the presentation. So we have a gap of enforcement at EU government, at the governments of member states. The Commission wears many hats. So, it has the hat of the guardian of the treaties. We have reached an understanding now where guardian of the treaties means also broader stability in member states, democratic stability in order to really apply EU law. But the Commission can also be the guardian of the treaties in terms of holding the purse strings. And I think the proposals for rule of law conditionality are very interesting. There is another avenue, another idea which was mooted for the European Public Prosecutor's Office, which is the new EU body monitoring compliance with the EU budget, that EU budget should be conditional upon member states' participation in the European Public Prosecutor's Office. Currently, Poland and Hungary do not participate. So, that is also interesting to think about when we think about rule of law and financial conditionality, that we have really the possibility of withholding funds from countries who do not participate in the main enforcement mechanism for the EU budget, in a sense. So, there is this asymmetry there. So the Commission, I think, it's up to the discussion also to see whether it is using what it has in its disposal and how active it can be. But from Laurent's presentation, I get the feeling that he thinks, but maybe we can discuss what people think, that currently the main way of really the EU developing an answer is via the Court of Justice, so, and via courts, in a sense, where the political process is really so weak. So, I think a question that we can discuss is whether the courts, this is really the real way currently that EU law can give a real answer to the rule of law. And with courts, there are two levels. There is the level of the Court of Justice, and we heard a lot about, the Court of Justice really increasingly being called under both infringement and preliminary references procedure to rule on the rule of law. The question, of course, then is compliance, and and how do you make sure that Poland, Hungary, Romania comply, with what the court orders, in a sense, and that is really a big question mark. But I think there is another level, which is the level of national courts. And I think that this is really very interesting to examine. There is, of course, the national courts in the countries in question. And the question, as Laurent said, how many independent judges will be left really to try to have a cooperation with the Court of Justice. But also there are the national courts in the context of implementation of other EU policies. And there we go to an area closer to my main, if you like, EU field of expertise, which is the European arrest warrant and mutual trust in judicial cooperation in criminal matters, where EU law has really established a system of dialogue between national courts. So not only between national courts and the Court of Justice, but between, let's say, a court in France who is asked to execute a European arrest warrant from Poland. This court can only execute this warrant if it's satisfied that execution is compliant with fundamental rights and the rule of law. If there are concerns, then this court is asked to send questions to its counterpart in the country which issued the European arrest warrant in order to see whether these concerns are founded or not. And currently there's a very big debate about the extent of this dialogue and how many questions should be asked, and whether the finding that there are systemic rule of law deficiencies or backsliding in the issuing member state is enough for cooperation to stop. The Court of Justice has said no in a very recent judgment of December 2020. It said that finding systemic deficiencies is not enough for the system to stop. You need really to examine the impact on the individual affected. But of course, this raises many questions that we can discuss later on. I mentioned this example, although it's not one of the key rule of law judicial avenues, to show that there is another avenue for scrutiny, which comes from national judges in member states other than those directly being targeted really by the EU institutions. And perhaps it is national judges in the Netherlands, in Germany, in France, who can continue raising these questions at the level of horizontal bottom-up cooperation with their counterparts in rule of law challenging countries. I will stop here, but I'm looking forward to the discussion.
Thank you so much, Valsamis, for what were indeed some very complimentary, I think, comments to the presentation made by Laurent. My suggestion, Laurent, would be that I will go back to some of the questions raised on the chat, and maybe when answering those questions, you may want to relate back to some of the comments made by Valsamis, or indeed address some of those comments directly at that stage. So just a kind reminder to everyone here in the audience, do not hesitate to raise your questions on the chat. The first question which I would like to ask, and it's actually a kind of compliment, if you like, to what Valsamis commented upon, and which relates indeed to this idea of diversity of rule of law traditions across Europe. And I know that this is something we have already discussed quite extensively together, Laurent. So this idea that when you compare the English rule of law with the French état de droit, with the German Rechtsstaat, that we are actually talking about rule of law traditions, to use that term, which are all very distinct from each other. In that sense, in the history of the European integration process, the Court of Justice of the European Union has very much played this kind of role of creating bridges between what the Belgian legal theorist Walter van Gerven called the unbridgeable. So the unbridgeable being those different rule of law traditions. And the Court of Justice has always used some innovative tools, if you like, indeed, to reconcile those different rule of law traditions by taking either rights-based approach or by referring to more abstract principles such as proportionality. So the question here is, what has changed, and why is it now way more difficult for indeed the Court of Justice of the European Union to bridge, the unbridgeable? Maybe that the answer is, okay, there is these illiberal definitions of the rule of law. If you can have indeed an illiberal understanding of the rule of law, so what are the factors which explain why it has become so difficult, if you like, for the Court of Justice to address what is and what are indeed those fundamental threats to the rule of law as you've described them today, Laurent? A second question relates to the COVID-19 pandemic. And the question was, to what extent do you believe that the COVID-19 pandemic is also likely to worsen the phenomenon of rule of law backsliding, given that in general governments have had indeed to introduce a new and, between brackets, often poorly scrutinized legislation promptly? So probably a question which indeed does not only apply to Hungary and Poland, but which also obviously also applies to those states. And then there was a question which relates to the beginning of your presentation, Laurent, because you indeed referred to a number of indexes, such as Freedom House and other. And the question was, what are the factors to measure the level of autocracy in one particular state? So if you could maybe go back to that point. So my suggestion would be that we start up with those three questions. We start with Laurent, then Valsamis, if you want to come in, you just let me know. And then we will hopefully still have time for a second round of questions.
Thank you very much. I will offer brief answers, and in fact refer to you to my writings to get the full answers you need regarding definitional issues. Actually, Mathieu, I don't really agree that the Court of Justice is struggling with anything. That's not the issue. In fact, what we're seeing is just authoritarian regimes trying to essentially raise non-existing definitional problems to hide, essentially to mask their attacks on their own national understandings of the rule of law. If you look at the Polish-Hungarian understandings of the rule of law, fully in line with the understanding adopted, defended by the European Court of Justice, European Court of Human Rights. So it's a non-existing problem, which is simply being used to distract from the dismantlement of the rule of law, at least from my point of view. I also don't quite believe that we waited for the Court of Justice to actually for the rule of law to kind of migrate between the different legal systems. In fact, if you look at the French concept état de droit, it's very much influenced by the German concept and also by the British English concept of the rule of law. And that was happening way before the 1960s. In fact, in the Rechtsstaat principle influenced French lawyers in the 1920s, 30s. So that was before, in fact, European integration started. French état de droit, that's Rechtsstaat, and then we also, which inspire Italian lawyers, Spanish lawyers. So essentially, constitutional concepts have been migrating across European jurisdictions way before European integration. But you're right, essentially, yes. The case law of the European Court of Justice and the European Court of Human Rights has harmonized, or at least essentially helped this consolidation of a core consensual meaning of the rule of law. If you look beyond the legal understandings of the rule of law, what is fascinating as well, there was a big public poll conducted by the European Commission regarding the rule of law in each of the EU countries in 2019. And there is 80% consensus on what the rule of law means, and also on the need to better protect it, including in countries where the rule of law is destroyed. It was a Eurobarometer from 2019, May 2019, if I remember well. But if you want to know more about definitional issues, may I recommend the reading of 2 Reconnect working papers. Mathieu, I can give you the references later. But we published 2 big papers last year, essentially discussing the meaning and the scope of the rule of law in the European legal space. And we went through each country, see what the constitution and lawyers and judges had to say about the rule of law. And essentially, we kind of have the same understanding. So my bottom line, I wouldn't pay too much attention to the argument that the rule of law is not defined, cannot be defined in EU law. It doesn't really hold waters. In fact, those arguing this point in the Court of Justice, they're not even aware of their own national understanding of the rule of law. If you look at Orban, if you look at the pre-Orban case law of the Hungarian Constitutional Court, fully in line with the understanding to be found in Regulation 2092/2020. So a non-issue. Regarding COVID-19, I'm not an expert on COVID-19, but yes, you're right. It has had a dramatic impact on rule of law across the board. I would recommend you reading the excellent work of my colleague, Dr. Joel Grogan, who's now publishing essentially plenty of country reports on the German legal blog, exploring the impact of the COVID-19 situation on democratic and rule of law checks and balances. What is interesting from an EU law point of view is that the European Commission did initiate 2 infringement actions against Hungary in relation to public procurement changes made under the cover of COVID-19. However, because I think there was a question about the situation in Hungary, the exceptional powers Orban gave to himself, which in my view violated several provisions of the EU Charter, were never challenged by the Commission. There was a very good legal submission by British barristers, I think Blackstone Chambers. They published something, a legal opinion on the situation in Hungary last spring or so. I can find the reference for you, Mathieu, if the students are interested, where they concluded that several provisions of EU law, including provisions of the EU Charter, were violated by this exceptional regime. and yet no infringement actions. The only 2 infringement actions initiated by the Commission very late are about public procurement rules and asylum / immigration rules. So there is a kind of a reluctance from the Commission, it would seem, to actually sue member states for what they've done under the cover or under the pretext of COVID-19. Final question was about, what was the last question? Sorry, I cannot remember now. It was about, I wrote down measures, but I forgot to, you have to unmute yourself, Mattia.
Sorry for that.
Yes.
It had to happen to me. So there was a question on the factors to level autocracy.
Ah, yes, I remember now, about the World Justice Project and Freedom House. It's not an easy question to quickly answer, because essentially all of these reports, indexes are based on many different factors and sub-factors. The World Justice Project, from memory, it's about 10 benchmarks, more or less, themselves. Each of these benchmarks then is further detailed into between 10 and 20 sub-components. Same story for Freedom House, same story for, in fact, every single rule of law index. So you need to look at each of them, but they tend then also to reflect the viewpoint of experts, but also the opinion polls, plus essentially, so just kind of, so experts plus opinion polls. So they're not always perfect, but they give you a good idea of trajectories. So you can quite easily detect the patterns of countries on the wrong, going the wrong direction. Regarding the VDEM Democracy Annual Report, for instance, they also use, again, about 5-6 benchmarks, themselves essentially consisting of sub-components. So not very easy for me to summarize. But essentially, as regards the EU, what is clear is that we have 2 countries which are very highly problematical, one of which is no longer a democracy since 2019. This is painful to admit, but the EU is no longer a union of democratic states. There is at least one which is not. And on current track, my expectation is for Poland to become the EU's second autocratic country by 2023, especially if next year they go completely ballistic and they start using their sham capture constitutional court to openly violate ECJ judgments, which they have already done implicitly last year. And the Disciplinary Chamber of Poland, by the way, formally nullified the judgment of the Court of Justice in AK of November 2019, the one which essentially made clear that the Disciplinary Chamber itself is not a body, is not a court within the meaning of EU law. So can you imagine you have a body found not to be a court within the meaning of EU law, which is nullifying the judgment of the Court of Justice, finding that it is not a court within the meaning of the EU law. But this is where we are today, sadly.
Thank you, Laurent. Valsamis, for a quick reaction, if you want to comment on any of those points.
No, just to say that what is interesting is that the Court of Justice has been quite confident in defining the rule of law and its elements, and it applying it in many different policies. So, you know, it has a very confident case law on judicial independence and so on. And I guess the question is to what extent national traditions and their interactions have had an influence on that. And if there is a consensus, then what has been the influence on that consensus?
Thank you, Valsamis. I still have a number of questions on the chat. You called for more creative lawyers to work for the Council, Laurent. So if you had to be one of those lawyers working for the Council, what would be the kind of solutions you would suggest to reform, to address Article 7, Paragraph 2 related issues? Is treaty revision the only way, or indeed are there other ways which could be used indeed to address this stalemate or this pact which you described in your presentation? Then I also have a question from someone I think you may know, called Professor Petra Barth from Central European University.
Yes, I think I do.
A very warm welcome to you, Petra, and thank you for being with us this evening. So the question here is, what do you think is the relation between the annual rule of law report and the conditionality regulation? Is the former or are its background documents of any use in justifying the triggering of the letter? Question mark. And second, the cases with the outrageous cases you described against Polish judges. Could you please maybe be more specific in terms, I'm the one rephrasing here, in terms of qualifying and describing those so-called crimes, and here I use quotation marks, crimes Polish judges have been charged with. So maybe we can start with those questions and then see whether we have some more time for last round.
Thank you. Thank you for the excellent questions. What a great audience. Creative lawyers was the first question. I mean, we can talk about lawyers from the Commission and the Council. In fact, the lawyers in the Commission are even a more crucial role to play than the lawyers from the Council. Let me start with the Commission lawyers. For instance, I mean, you don't really have to be creative. I'm saying you just have to interpret EU law in a rule of law enhancing way. What do I mean? Let me give you two concrete examples which drove me mad back in the days. I've been arguing for many years, including with Petra, that, for instance, Article 19, paragraph 1 of the TEU could be used to protect judicial independence because essentially it's just a concretization of Article 2 TEU. This was done by this was essentially green-lighted by the the Court of Justice in a preliminary ruling case in 2018, known as the Portuguese judges ruling. Until then, the Commission had refused to bring an infringement action directly based on Article 19, paragraph 1, which is essentially where you're going to find an obligation imposed on national member states to provide effective judicial protection. So I'm simplifying. The Commission has refused to do that, including in the case mentioned by Valsamis about Hungary. So Valsamis was referring implicitly to the Commission versus Hungary 2012-13 saga, where essentially they purged all of the senior Hungarian judges. And the Commission felt it could not use this Article 19, paragraph 1, which was there already available, ready to use, ready to be microwaved, kind of an oven deal treaty provision ready. But no, they decide to use age discrimination. So based on age, Petra has written about it. And obviously, when you sue on discrimination grounds, then it's very easy for the national governments to find remedies addressing the discrimination issue and forgetting the judicial independence issue. So it was, yes, a win in Luxembourg, but they lost completely the war, but they were happy. And it took them a lot of criticism from external lawyers, external academics, in fact, for the Court of Justice to show the way. And then the Commission finally brought its first infringement action on the basis of Article 19, paragraph 1, after the Portuguese judges ruling, which was only due to Portuguese judges bringing a case to the Court of Justice. If it wasn't for the preliminary ruling, essentially, and the Court of Justice showing the way, the Commission is always waiting, which is very frustrating from my point of view, waiting for the Court of Justice to lead the way in the preliminary ruling context, which means that infringement actions are always 2 or 3 years too late because the Commission is waiting instead of being proactive. Another example, I mean, I could multiply the example. The Polish forest infringement case, so long story short, in Poland, they decided to log trees in a very spectacular forest. Infringement action brought by the Commission, interim measure adopted by the Court of Justice, interim measure not complied with by the Polish government. Why? Because it's their God-given right to cut off trees. That was more or less the argument, to disobey ECJ interim order 2017. The Commission failed to ask for financial sanctions until the Court of Justice made it clear that why are you not asking for financial sanctions during the hearing of this case? So the court had to strongly, embarrassingly nudge the Commission lawyers into asking for financial sanctions, which they didn't ask. Why? Because Article 279 of the TFE, which is about interim powers of the Court of Justice, does not mention explicitly you can ask for financial sanctions. So you see this narrow interpretation of treaty provisions by the Commission lawyers. And so they did in the end ask for financial sanction, and the Court of Justice confirmed that under Article 279, the effectiveness of EU law and the broad scope of interim powers conferred on the Court of Justice means that the Court of Justice can impose penalty payments on national governments in the context of interim measures. As for the Council lawyers, I mean, I don't want to be mean, so maybe I shouldn't really, I should stop there. But for instance, let's look at, it's not even the question of being creative here, it's a question of integrity. So I'll be stronger even. When you argue that Article 7, Paragraph 1 hearings cannot take place in the COVID-19 situation because video conferencing would be a breach of EU primary law, then you really have strong questions to ask yourself. Who are you, I mean, who are you working for? Are you working for a client, or are you have you pledged essentially to essentially defend and protect EU law, including the EU treaties? So my questions for Council lawyers would be actually not about their method of interpretation, but rather questions relating to integrity, which actually in a way it's even more depressing than being very conservative in your legal approach. Regarding Article 7, what can we do about it? Essentially, it's for the Council to have the political will to make an effective use of Article 7. I mean, I've just mentioned the video conferencing, but there's another issue which is very, how could I put it very nicely? Another instance where the Council, in my view, violated EU primary law in order to make Article 7, Paragraph 1 as ineffective as possible. They have refused on the basis of what I think is just bogus legal analysis by the Council lawyers. They have refused to formally involve the European Parliament during Article 7 hearings in respect of Hungary, on the basis that it would violate the principle of institutional balance to have the European Parliament defend its reasoned proposal before the Council. Instead, the Article 7 proposal, I'm a bit technical here, perhaps a bit too much, but I mean, just to show you the completely ridiculous nature of the situation we find ourselves in, the European Commission is defending the proposal of the European Parliament under Article 7, Paragraph 1, when the Commission itself has refused to bring an Article 7, Paragraph 1 proposal. Why? Because the Council is of the view that you can involve the Commission, but you cannot involve the European Parliament. Why? For legal reasons which do not hold waters. I have written on this if you're interested about Article 7 and what can be done to make it more effective. And then you had the third question, which was from Petra, about the rule of law report and the conditionality regulation. I mean, there's nothing preventing the Commission from adding a section in the next edition of the rule of law report. These are a specific section about findings which may connect to the rule of law conditionality regulation. So kind of a rule of law concerns which may connect to EU budget / EU financial interest. For the time being, I don't think the Commission is going to do that. The Commission is of the view that rule of law reports cannot be directly used for infringement or legal processes, as far as I understand. But I think there is room for improvement regarding the rule of law reports to make it more kind of ready to be used for legal actions. But that's not apparently the signals I'm getting from Brussels. Regarding the crimes committed by Polish judges, so I mean, it's difficult to summarize. There's so many bogus sham criminal charges being brought against judges. The most recent one, the most ridiculous one I've seen recently, and then I'm going to give you the example of Judge Igor Tuleya. There is another judge who has actually brought a case before the European Court of Human Rights, like Judge Tuleya, Zuek, if I remember well. Now I'm a bit tired. But it was 5 years of investigation regarding this specific judge. You know why? Well, so the Polish government has spent 5 years investigating a specific judge who was the former spokesperson of the former National Council of Judiciary, so kind of a senior judge, a prominent judge. They've used anti-corruption bureau, they've used criminal prosecutors, and after 5 years of harassment is now being brought to trial for what? The crime of not having declared €200 in VAT when he sold his 37-year-old tractor to his neighbor. So 5 years of harassment for which crime? What crime did they discover in the end for which he's going to stand trial? He forgot to pay 200 euros in VAT. I'm not even sure that he's actually due to pay a VAT on the tractor because the tractor was from the 1960s. But that gives you an idea in the kind of the Soviet-style tactics being adopted to harass judges. In the case of Judge Igor Tuleya, he issued a ruling against the ruling party. So he issued a ruling against the ruling party for violating the rules regarding the adoption of the Polish budget. So some serious matter. And now they're bringing criminal charges. Why? Because he gave the judgment in open court, having welcomed journalists in the courtroom when he gave the reasons for his judgment. So he's the subject of criminal charges, essentially on account of the content of the ruling, but officially because he welcomed something he is entitled to, members of the media in the courtroom. So a complete sham proceeding. I can multiply examples of harassment against judges, but I don't have to do this because there is a very good reports published mostly by Justicia, which is the largest association of Polish judges. So Justicia, if you're interested, that's the name. The spelling might be not correct, but yeah, you'll find it. They have published a 5-year report documenting 5 years of harassment against judges and prosecutors, and the report is about 200 and 300 pages long. So it gives you about, I think, between 60 and 80 examples of judges and prosecutors. I can't remember the title. I think it's called the 5 years of harassment of 5. So essentially, this is industrial scale harassment of Polish judges, but also Polish prosecutors. By the way, we tend to forget prosecutors because the Commission is of the view that EU law cannot be used as such to protect prosecutors from state harassment. But just to give you an example of what's happening to Polish prosecutors, in the middle of the recent COVID-19 lockdown, they decided to punish prosecutors or those not refusing to toe the line by asking them to move within 48 hours to a new prosecutor's office 300-400 miles from where they were. Failing what, they would be subject to disciplinary measures up to dismissals from the prosecution's office. So these are the kind of tactics they use. And obviously, we could also talk about what they're doing to academics. We have the example of Professor Sadurski, who is the subject of something Professor Bard is an expert on, SLAPS, strategic lawsuits, essentially to bully people, to scare people into submission. Professor Sadurski is the subject of 5 or 6, I forgot now, civil and criminal defamation lawsuits in Poland for criticizing the ruling party. Professor Sadurski being one of the world's authority when it comes to comparative constitutionalism. He wrote a recent book. If you want to know more about Poland, I can recommend Professor Sadurski's book on Poland's constitutional breakdown, Oxford University Press, 2020 or 19. So, thank you, Mathieu.
Thank you very much, Laurent. And I'm aware of time here, and I know that we all suffer from, let's say, Zoom fatigue or whatever you want to call it. So I guess it's now time, to end this event. And before I do so, and Laurent did refer for very good reasons to the research he's been doing, the research that Professor Bart has been doing on those issues of rule of law backsliding. So my advice would really be, if you want to know more about it, a good way to find out about this research is indeed to look at the website of the Horizon 2020 Reconnect project, which does not only bring together Professor Bart and Professor Pesch, but also scholars from all over Europe, including from Hungary and Poland. So it's definitely, a good way for you to engage and to get to know more about those issues. So I would like really to thank our speaker, Laurent, for this very thought-provoking presentation. Many thanks, Professor Pesch, and also to thank very much Professor Mitsilegas Valsamis for having been with us this evening for what was, I think, a very, very interesting and thought-provoking event. Many thanks to the audience, to all the participants, and obviously, in particular, a big thank you to the students and to the AGQS for also having made this event possible. Let me now wish you all a very, very good evening and a relaxing, hopefully sunny evening as well. Bye-bye.
Thank you, Mathieu.
Thank you, Mathieu.